Welcome everyone. Thank you for joining us today. In this Queensland webinar, we're talking about the new regulation modules which commenced on the 1st of March. I'm Nikki Jovetic from LookUpStrata, and for this webinar session, I'm joined with Todd Garsden from Mahoneys. Please feel free to share the recording that you'll be receiving later today with neighbours, committee members and other staff members or anyone you think who would be interested in this session. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent legal advice before acting on the information contained in this session. I'll be handing over to Todd soon to give an overview of the changes to the regulation modules and what these mean to you. This will be followed by a Q&A session. I'm delighted to introduce Todd Garsden from Mahoneys. Todd is an experienced property lawyer who specialises in body corporate law. Todd predominantly acts for body corporate managers and lot owners on all matters affecting bodies corporate. Todd is an active member of the Strata Community Association Queensland. In 2019, he was appointed to the SCA Legislation Committee and assists in making submissions on behalf of the SCA on issues such as legislative reform in body corporate law. More recently, Todd was appointed to the SCA Membership Committee. As Todd is also a body corporate committee member, he understands the day-to-day requirements of administrating a body corporate. Todd has a focus on achieving practical and commercial results for his clients and understands the market in which bodies corporate operate within. Todd also provides body corporate managers and other industry stakeholders with presentations and training on matters affecting the body corporate industry. Todd and the team at Mahoneys are also regular contributors to LookUpStrata, providing articles plus answering some of the many Queensland Q&As we're receiving from our audience. Welcome, Todd. I'll hand the discussion over to you now.
Thanks, Nikki. Very nice intro. So I suppose what we're planning on doing today is talking about the new regulation modules that started at the beginning of this month in Queensland. So I'll do a quick overview of what those are. And then at the end, we already had some questions submitted that we'll try and cover off. So if there are questions that come up during the overview, then feel free to send them through and Nikki's going to try and coordinate them in the background. So I guess I'll jump into the material now and we'll catch up with Nikki soon. So, I mean, the main part of obviously the new regulation modules was really split into 4 categories. And that was first one, electronic voting, committee meetings, general meetings, and then more of an information section at the end. So as most people are probably aware, the big ticket thing was the electronic voting, and that's to allow committee elections, general meeting motions, including secret ballots. The big thing for the body corporate before they can start having these electronic voting meetings is really to make sure that they pass an ordinary resolution beforehand, because you can't have the electronic meeting without that ordinary resolution. A lot of the changes, particularly those related to committee meetings, are really day-to-day functional matters that committee members, body corporate managers and lot owners that are involved with committee decisions are really affected by. So some of them are clarifications, some of them are very similar to what the position used to be, and there are some fairly big fundamental changes. So a lot of the questions that have come through already relate to co-owners of a lot. The old position was it was quite hard for 2 co-owners to become on the committee together, but they've made it pretty clear now that if 2 co-owners own more than 1 lot, both those co-owners can then nominate for the committee based on the number of lots that they own. So that's a really helpful change that probably avoids a lack of committees and a lack of those EGMs to go and appoint a committee down the track. A new concept that's been created is something called a minor committee. So a minor committee will generally apply when there's a number of lots in the scheme, but only 3 owners in total. The general rule around minor committees is that those 3 owners can decide amongst themselves who is going to be each position on the committee. So they can change their mind whenever they want between chairperson, treasurer, secretary, or even an ordinary member and someone else putting their hand up for the rest. So that's probably a functional one that is a little bit new to get used to. The committee ballot appointment and removal process hasn't changed, but there's a lot of sections that did that really just clarified the process of how those things work. So that's been probably a helpful clarification that answered some questions in adjudicators' orders over the last number of years. Another big change for committee meetings is that lot owners now have a right to submit motions to a committee meeting. And then the committee has a 6-week period to answer those motions and make a decision. There's a number of issues around that. So if the committee doesn't make a decision within those 6 weeks, they have the ability to extend it to 12 weeks, but they need to come up with a decent reason to do that. And there are limits around the number of motions that a lot owner can submit to the committee, which is going to be tested, I think, quite soon in the adjudicator's office, because owners are going to sometimes take advantage of that ability to have motions considered. Committee meeting attendance is another thing that's changed. So now it can be done electronically, and lot owners can also appoint a representative to attend that meeting when previously they didn't. So you've still got to give the normal 24 hours notice beforehand, but there's still the same rules about being able to speak during that committee meeting and having to be excluded from particular discussions at the meeting. A good clarification that's been made as well for committee meetings is that committee members who owed a body corporate debt lose their right to vote. So this is causing a little bit of discussion behind the scenes, because all the explanatory material related to committee meeting voting being unfinancial said that if the person nominating you was also unfinancial, that person loses their right to vote. But that doesn't quite line up with how the legislation is drafted. So that's a little one that I suppose is still being ironed out, even though it's nearly a month old. A good practical change as well is that committees that are making decisions outside a committee meeting, your old VOCM, has a 21-day drop dead date. So that means it doesn't take 21 days for the committee to make the decision. It means after 21 days, if they haven't made a decision, it's basically deemed to be a no vote. So that'll speed things up from an owner who's trying to get things challenged in the Commissioner's office where the committee's not quite committing one way or the other to a decision. It's a deemed no, so they can go and challenge that. Part 5 engagements, when your body corporate manager becomes the committee, that can also now be approved by an open ballot rather than a secret ballot. It's a little bit of a technical one that I'm not too sure many people will take use of, because if they can't get a committee appointed in the first place, there's probably no use changing the type of way that you get that Part 5 agreement engaged, but intended to be a helpful one. There's some more restrictions that have been put on committee members about benefits that are received from service contractors. So this is one that fits in with a theme of disclosure, which we touch on a little bit later as well. A really practical change that's been introduced is that the committee now has the power to exceed its spending limit in relation to insurance. So a practical problem that everyone was intentionally breaching the previous legislation was when you get your insurance quote, it's got a time frame for approval that is a lot lower than the time frame to actually go and get approval. So that's been a really helpful change that was put through to allow committees to properly put insurance in place without that decision being challenged by an owner. They're probably a very brief overview of the main committee meeting changes. So some of the general meeting changes that have been made relate to lot owners having the right to submit a motion for the first AGM. So this may not happen very often because normally the developer's still got quite a lot of control around that time, but it's probably a good one to be aware of for those off the plan purchases that do want things considered early on at a general meeting. A really big change that's created a lot of discussion behind the scenes is the shift from motions with alternative to same issue motions. And there's a specific question we'll answer later in relation to how this works. Some people are pretty in favour of this change. Some people aren't such a big fan. But the really interesting thing is I think this deals with a problem that previously existed where you couldn't have motions with alternatives that dealt with different resolution types. So this dealt with that really big threshold question. And I think once people become more comfortable and used to this change, they'll see the benefits in it. It's just going to take a couple of tries at it to really understand how it works. Essentially, it puts a lot more focus on no votes as well as yes votes. So in a nutshell, the way it works is you've got your group of same issue motions, and they're independently considered. They're just basically sectioned off in the agenda so that you can delineate this same issue motions with the rest of the agenda. All the motions are independently considered on their own merits. So once you go through and work out which motions passed and which ones didn't pass individually, you don't care about how they relate to each other. The next step is to work out which one of those same issue motions had the most amount of yes votes. The one with the most amount of yes votes is what the body corporate's decided. There's a few little tiebreaker rules. So if, let's say, we had one that both had 10 votes in favour, we look at the no votes, and it's whoever had the least amount of no votes is the motion that's passed. So it's really important that if you really want something to pass, you don't just get people to vote for yours, but you also get people to vote no for the other motions. If it's still a tie, then you go to the old method of chance, which can flip a coin or draw straws depending on how many are left over. Developer handover material. There's a list of things that early on in the schemes, general meetings, the developer must hand over to the body corporate at the general meeting. A lot of the time, these things are minuted, but don't necessarily always happen. So that list of material that the developer has to hand over to the body corporate has gotten a bit longer and more specific, and that's to help the body corporate primarily with building defects. And building defects is a bit more of another theme that you can see in some of these other changes. Another one that people might be a bit familiar with is the changes to a quorum for a general meeting. So previously you needed 25% of voters and at least 2 people personally present at the general meeting for the general meeting to have a quorum and continue. Otherwise, it's held over for a week. So that created a lot of problems when I think most general meetings wouldn't get that quorum, and then you'd have to come back a week later. So scheduling that can be a bit of a difficult situation. Also adds to the administrative costs for the body corporate manager. I have to run 2 meetings or 2 AGMs for every building instead of the one that you're supposed to have. So the legislation now allows you to reduce the percentage of voters to a minimum of 10% and reduce the number of people personally present to 1. So the intent is to remove the number of adjourned general meetings, make it a bit easier for the body corporate to manage its own affairs. To be able to reduce that quorum, the body corporate needs to first pass a special resolution. So in the next year, I suppose, there'll be a lot of bodies corporate that are passing that special resolution, which will then help them for next year's AGM. There's been some new limits put on the use of powers of attorney, where rather than someone attending the general meeting and bringing 30 or 40 powers of attorney and then voting a particular motion through, that's been restricted. So you can really only come to the general meeting with 1 power of attorney per family group. So that's a relatively big shift based on some fairly recent adjudicators' decisions that probably had some unintended consequences. When a motion's being ruled out of order at general meeting, the minutes now need to include the reason. I think a lot of people had that as best practice anyway, but now it's a mandatory requirement. Another change that fits in with the defects is really what I think is quite a good one, where at your second annual general meeting, the body corporate has to consider a motion to consider engaging a contractor to come and do a defect assessment. So it doesn't mean it has to be approved, but it has to be on the agenda. Owners can then vote for it or against it, but it's really going to help manage those critical building defects early on before we start verging on the 6-year cut-off periods, which is when a lot of buildings start to look at these problems, and by then it's normally too late. So there's nothing stopping the body corporate doing it on the 2nd, 3rd, 4th or 5th general meeting as well. It just means on the 2nd AGM, we have to have that motion considered on there. There's the ability along with the building defects, to have a defect assessment plan where standard format lots can also basically pull together to, I suppose, get some economies of scale to get a defect report, even though this is something owners are responsible for as opposed to the body corporate. And then it essentially allows the body corporate to project manage it on behalf of a number of different owners. So I'm not too sure many people will take advantage of that just because of the administrative difficulties in arranging that, but it might be useful for some standard format lot owners. The last set of changes really relates to information. So the body corporate, previously, a lot of bodies corporate passed motions that dictated how documents were going to be delivered to owners, and it was more of an opt-out situation, and a lot of people tried that on, even though there wasn't really the power to do that. But what the legislation now allows bodies corporate to do is when they agree with a person, they can send it in a particular way. So what that means is you can send body corporate documents by Dropbox or email or a link or file sharing software, as opposed to it needing to be posted or something like that. So that's a functional one that probably is just catching up with some of the electronic meeting changes as well. Previously, owners had an obligation to give body corporate information within 2 months. For example, if you're entering into a long-term lease or you've sold the lot, that period's been shortened to 1 month. It's intended to help the administration of the body corporate, but a lot of the problems associated with this change isn't necessarily it taking too long. It's not being sent at all. So it might flush out a few problems, but it's probably not going to deal with the biggest ticket problem there. The role needs to be updated by the body corporate within 14 days. Previously, it was a longer period, but again, I think a 14-day period is quite generous. So if it's taking longer than 14 days, there's probably some larger problems there. And about this time last year, there was an adjudicator's order up north that talked about body corporate documents being sent formally to the body corporate that everyone had generally accepted can be sent to the body corporate manager, even though it requires being sent to the secretary. So they've added in a specific section saying that the body corporate manager can accept delivery of documents on behalf of the secretary. So that's a really practical and helpful change, and really ties them up quite well together. So I suppose that's a fast-tracked version of what the new 2020 regulation modules put together. And then I suppose the whole point of this webinar is really the Q&A session, which I suppose Nikki and I will jump into at the moment.
Thanks very much, Todd. That was excellent. Yeah, we have got a few questions that we've got here, which will expand on some of the points that you've mentioned in the summary there. So thank you very much for that. So yeah, if we jump straight into it, one of the first questions was to do with the same issues motions, and it was an example that was given. We would be interested in how a group of same issue motions would look if you had various quotations and colour considerations for something like a roof repair. For example, we have 2 quotations for roof replacement as the cost is over $10,000 for ColourBond roofing. We have 1 quotation for roof repair of around $5,000. We have 2 quotations for roof replacement of the same product, which was an existing roof tile, and that's for $15,000, and this would be the same colour as the existing. And then we have 2 colour options if they go for the ColourBond roofing. How would we represent this as a group of same issue motions?
Really good question. And I think this is a good example of the practical help that a same issue motion set can provide, because it really allows the body corporate to give the flexibility to vote on particular issues without the conflict that can sometimes arise with motions with alternatives. So it really is a very simple way of achieving it that you didn't have to worry about with motions alternatives, where essentially you put all the motions for each option in the agenda, group them together so that they become a same issue motion, and then run through the process I briefly went through before. So I mean, you've got your 2 quotations there because the cost is over $10,000. So that would really have, contractor A and contractor B. But the good thing here is because you're also looking to do with different colour options, you've really got 4 different motions there that you want to put forward. So it's contractor A, colour A, contractor B, colour B, and then all the other combinations you can come from that. Owners then have the ability to vote for which ones they're okay with and which ones they're not okay with. And then when you run through that process of the same issue motions, you're going to come up with essentially what's the fairest result based on owners' views for yes and no. So it really brings in the no vote quite well. So short version is put through all the different options that can come out and then leave it to owners to vote yes or no for the ones they like and don't like. And then if you follow the process, you'll get the right outcome spat out.
Okay, thank you. Another one that we had come in. With the new legislation, is it possible for joint owners of one unit to be on the same committee? And I know you did cover this briefly. Previously, you could get someone else in the complex to nominate you. They effectively gave you their right to take their option to become a committee member. Is this still the case?
Yeah, and I think there's a little bit of confusion around how this works. The short answer is yes, it is the same case. So that old rule about needing someone else to nominate you to go on the committee really related to when there was no one else or when you were trying to get committee members on there, because there was a section in there for co-owners that said only one co-owner can be on the committee, even if those co-owners owned multiple lots. So the only change that's happened is more flexibility to allow that co-owner to get on the committee. It's not necessarily a restriction. It's opened it up more than anything else. So the only change is if there is a co-owner, those co-owners that own more than one lot, they can both nominate individually and they don't need that other person to nominate them. But the other person can still nominate them if that's how they want to play it out.
The committee now has a maximum of 6 weeks in which to respond to a motion put by a lot owner and extended if needed. This can be seen as a standard time to respond. Is there a reasonable time in which the committee should respond in normal operational circumstances? For example, if a request to keep a pet is made, 6 weeks appears to be unreasonably long. And then during the discussion, we also had a question come in, if you could go over the 21 days is a no vote. You mentioned that during the discussion.
Okay, sure, yeah. So in relation to those first comments, yeah, committees can turn around decisions a lot quicker than the 6 weeks. But I suppose the new legislation gives them 6 weeks to make the decision. So I think if you were expecting an earlier decision, it's going to be very hard to get an early decision if the committee does want to take their 6 weeks, because ultimately what your rights are to go to the Commissioner's office and ask for a decision to be made earlier. And I just can't see an adjudicator saying within a period of less than 6 weeks that the committee is being unreasonable by taking more than 4 weeks or something like that. So I think there's a bit of balance here where a lot owner is getting a lot more out of these regulation modules by setting a deadline. So I think by saying we should be taking less time than what the deadline is, we're probably not going to get that far with how it's going to be interpreted. So I think it's going to be very hard for an owner to force a committee to take a time less than 6 weeks if the committee wants to take 6 weeks. And in this relation to the second part of that, the way that the 21 days works is more of a drop dead date as opposed to a no vote. If the committee makes the majority decision within those 21 days, then it's absolutely an approved committee decision. It's really if some committee members haven't put their vote in, maybe we've only got 2 answers so far, and we need 4 to get the majority resolution. It just means after those 21 days, the committee's decision deemed is a no against the motion. And what that does is it opens up to the owner to go and take further action down the track.
Excellent, thank you. Sorry, I'm just jumping in chat at the same time as I'm speaking to you, Todd. Okay, there's also one from one of the members that came in today into the chat. Is a motion submitted by a lot owner the same as a lot owner asking for a decision to be made by the committee? And can a motion be a question seeking clarification of the committee's progress on implementation of a previous action agreed to at a committee meeting?
Yeah, that's a really good question. And I think it's going to have to take a lot of clarity from both owners and committee members about how these things are going to be treated. I can't see a request for information or asking the committee for an update or just a general question as being a motion. That is really just communications to be tabled and considered by the committee. So perhaps out of an abundance of clarity, the owner should either say if they want it to be a motion or say that they don't want it to be a motion, and then it can be treated in that way, keeping in mind there's those 6 weeks if you do want it as a motion. But if it's not a motion, you obviously don't have a deadline, but you might not be using up your cap of how many motions you can submit within that rolling 12-month period. So I think it's not really up to the committee to determine whether or not your communication should amount to a motion or shouldn't. It's really whether it is a motion or isn't. And I think asking a question wouldn't amount to a motion. It's just communications.
Excellent. We've had one, just can you summarise the resolution needed to be made by the body corporate to enable options for meetings offered in the new regulations?
Yeah, there's a few different motions. So I suppose the short list is really the 4 different in concept and I suppose related motions for electronic voting. So that's for your ordinary, for your open ballots, secret ballots, committee ballots, and secret committee ballots. So that's one that I see sort of 4 different ones that are really related to the same. There's the quorum changes. So that's probably another really important one to reduce your quorum, and that one's a special res. The other motions, I suppose, is the defect motion at the second AGM, and there's a bit of a list, I suppose, as well, because you can change for your late arrangements how many people are going to be on the committee for that. There's another motion, I suppose, for Part 5 arrangements to become open ballot instead of secret ballot. So perhaps after this, Nikki, we could put the full list together and send that out.
Excellent. We could certainly do that, and we'll send that out via email to the registered attendees today, which would be really helpful. Are there any changes to dealing with poor behaviour at a meeting, vexatious persons?
Still the same rules. So committee meetings, you've still got the right to kick people out if they continue to speak when not spoken to after you've given them the warning. And at committee meetings, observers still don't have the right to talk, but there's been no changes in relation to that type of conduct. But there might be in the Act if the Act changes come through. And
I understand in Queensland, a committee can decide on maintenance up to a value of $200 per lot times the number of lots in the complex. Has this changed? For decisions of greater expense, what is the process required?
Yeah, it's a good question. So it's kind of changed, I suppose. What's happened is there's been an exception to that $200 per lot rule, where if it's for insurance, the committee can exceed that amount. The one thing to keep in mind, though, is that $200 per lot number can be changed by the body corporate. So they can go to general meeting by ordinary resolution and make it $1,000 per lot, or a flat sum of $500 or $1 million, whatever the body corporate decides. So it's always good to check whether the spending limit has previously been changed. But what these regulation modules have done is they've added an exception to that amount, which is for insurance.
Can you please go over the 10% minimum for a quorum? Todd, did you say that the body corporate needs to pass a special resolution in order for this change to occur?
That's right. So previously the limit was 25%. You need that percentage of voters to send in a voting paper or attend the meeting. You can reduce that to any number between 10 and 25%. So you can reduce it to 17 or 12, whatever the body corporate wants. I think most people will go all the way to 10 rather than getting caught somewhere in the middle. But before that applies, you need to pass a special resolution first. So it's not going to apply to many bodies corporate yet because it's only been a month. So I'd expect over the next 12 months, you'll pass your special resolution. And then your next general meeting after this one is when you'll actually be able to have the reduced quorum apply to the meeting.
Okay, for part 5 engagement, does a special resolution require an open ballot? How does it work?
So for a part 5 engagement, if the body corporate hasn't done anything, it needs a secret ballot at the moment, which is when you engage a returning officer to count all the votes, and they're all done anonymously. What the new changes have done is they've allowed the body corporate to again put a motion on the agenda in advance of that taking place to remove the requirement for a secret ballot and allow it to become an open ballot. So again, in the next 12 months is when you'll see a number of these threshold motions go on to kind of flick the switch on something like that happening. And it's really the general meeting after the next one where you can actually see some of these changes take effect.
And I think at this stage, this is the last one we've probably got time for today.
Cool.
On sending motions into committee meetings, how many can be sent by the one owner per year? And where can I see the legislation detailing this, please?
You've got 6. So in a rolling 12-month period, so if you send 6 in March of 2021, you've got to wait till April in 2022 before you can submit another one. The body corporate can also, of course, they can accept extra submissions, but they don't have to. So it's really important, I suppose, for an owner to either pace themselves or really think about which motions are important to themselves before they start submitting them to the committee. So it's a rolling 12-month period. So you could space it out and do one every 2 months if you really wanted. But I think it's a lot of thought should be put in before you start burning through your limit.
Okay, that just about takes us to the end of the session, Todd. So thank you so much for your time today and for the
Thank you for organising, Nikki.
That we have in there, and we'll get the copy of the recording out to everyone later on today, and then as soon as you get the other information through to me, we'll get that out to everybody as well. And yeah, thank you very much for joining us.
No worries. Thanks, Nikki. Bye, everyone.
Thank you. Goodbye, everybody. Thank you.